the former president of the United States, Donald Trump, is on trial for rape in New York City. This is not a criminal case. This is a civil case in which a lady by the name of E. Jean Carroll, once a very popular gossip columnist in the New York City area, alleges that in the 1990s, Donald Trump raped her in the ladies' dressing room of a very highly regarded and well-known department store. You've probably heard of it, called Bergdorf Goodman. Trump has denied the allegation. How can this be happening 40 years later? Well, she accused Donald Trump of raping her, and he denied it. And in denying it, he made some very negative comments about her, not the least of which is that she's a liar. And then she sued him for defamation. Then the state of New York, in its infinite wisdom, opened up the statute of limitations for lawsuits on sexual assaults by surviving adults. So that gave her the opportunity to bootstrap not only her defamation litigation against him, but now a litigation against the rape itself. He, of course, denies this. At a deposition, he denied it. He confused a picture of this lady, Jean Carroll. He thought it was his wife at the time. But aside from that, he made clear and convincing denials. The problem is he's not showing up for the trial. The trial was in state court in New York. Trump's lawyers moved it to federal court in New York. Trump's lawyers then attempted to move it to federal court in Washington, D.C. Why Washington, D.C.? Well, they argued that because Trump was president of the United States at the time he made these words that allegedly defamed Ms. Carroll, among which are, she's a liar. He was the sitting president of the United States, entitled to say whatever he wanted at a press conference, and therefore the Department of Justice should defend him. And if a jury finds there's any verdict against him, it should be paid by the federal government. The courts have ruled against that. So then the case was sent back from D.C. to federal court in New York, and after numerous delays, it began with jury selection today. Will Donald Trump show up to take the witness stand and deny that he raped this lady? Apparently not. Apparently, he and his lawyers are satisfied with playing a videotape of his testimony at his deposition in which he denied that he raped her. She, of course, will have her testimony. There are no eyewitnesses. There are other witnesses in the case. There are women who claim they were similarly treated by Trump. There's the infamous Access Hollywood tape, and there are friends of the plaintiff to whom she made statements to the effect of, this guy raped me at the time of the rape. She never reported it to the police. There was never a criminal prosecution. There was never a police investigation. I can't predict where it's going to go, except it's before a very serious federal judge in a very serious federal court. And in my opinion, he should show up and deny this, but that's apparently not what he's going to do. When you don't take the witness stand in a criminal case, of course, you have the right, the natural right to remain silent. That right is expressly protected by the Fifth Amendment. The judge will tell the jury the defendant chose not to testify. You may not construe anything from his making that choice. You may not assume that he's guilty. You may not speculate as to what he would have said if he took the stand, because that right is an absolute right. I have given that charge many times in criminal cases. In civil cases, it's different. When the defendant does not testify, or as in this case, when the defendant doesn't even show up to the trial, you get the opposite charge. The judge will say to the jury, Donald Trump's the defendant in this case, and he's not here, and he didn't testify. And you can assume from his failure to come in the courtroom and his silence that his testimony would be against his best interests. You may assume that if he testified, you would disbelieve him. That's a very, very harsh charge for judges to give, but they do give that. I have, when defendants don't show up. Here's what I wouldn't allow. I wouldn't allow other women to testify that they've been abused by him, because that is irrelevant to whether this particular abuse happened. However, the state of New York has what's called the prior bad acts doctrine, which allows plaintiffs or defendants to tell a jury about similar behavior involving their adversary, and they can tell the jury about it. So if some other lady is going to come in and say, did the same thing to me in the Macy's ladies' dressing room, The judge is going to let them testify to that. I wouldn't. I don't think it has anything to do with this case, but I'm not the judge in the case. And this particular judge has exercised his discretion to allow that testimony.